Good morning, good afternoon, or good evening. Dear audience, on behalf of the Department of Law, North South University, it is my utmost pleasure to welcome you all to this lecture by Professor Richard Albert. And I'm especially thankful to Professor Albert that despite him being in some discomfort, he still has been very kind to agree to deliver his lecture for us. Before I hand over to Professor Albert to deliver his talk, let me say a few words about his today's topic. Professor Albert has written a paper on this very topic on which he will talk today. He has sort of argued that we are living in an era where democracy in different parts of the world is under threat. Authoritarianism in many forms is on the rise. And one answer to sort of democratic deficit in many parts of the world, according to Professor Albert's paper, is perhaps to have some sort of a world's constitutional code. Of course, Professor Albert is not starry-eyed. He doesn't think that we have that time to have that world's constitutional code in place right now, but through his very careful and eloquent writing, he sort of shows us that there are various ways that maybe in years to come, we could have a constitutional code. He also cites some cases where, particularly in Africa, and also hypothetically, he poses this question that had there been such a world's constitutional code, how would many Trump followers possibly react after the loss of Trump's election in the last US presidential race? He concedes that the very idea of a world code or a supranational code would be questioned by many perhaps. But as Professor Albert says, just because the time may not be right now, ripe for having an world's constitutional code, we cannot say that that project is an abandoned one. And if I may add, who in 1901 or 1920 would have thought that Europe would have a supranational code which would have jurisdiction on human rights? The very idea that citizens could bring cases against their own states in an international court would have been perhaps unthinkable even at the beginning of the 20th century. So what may look improbable today may not be so in decades to come. So even if that project may be sort of something too ambitious for now, that, as Professor Albert, as I understand, has written in his paper, that yes, this may not be the right time, but that is not a good convincing reason for us to stop thinking about that project. Maybe that thinking process can go on, and that is something that I think is the conclusion of Professor Albert's paper, and I look forward to how he delivers his talk on that, and of course I look forward to your questions, dear audience. Richard, over to you.
Well, thank you so very much for inviting me to join you all today. I'm really grateful for the opportunity to share some ideas that I have with you. Rizwan, thank you very much to you personally, to North-South University, the Department of Law for having me, and to all the attendees. It's really a gift, again, to have this platform to begin a conversation with you today. That's really what I envision for our time together. I'll lay out some ideas, and then I look forward to learning from you and your comments and questions. Today, democracy is declining all around the world, and so is faith in domestic institutions. In my view, defending democracy is an urgent challenge for us all. As you may know, there have been many suggestions about how we can protect democracy, and I think we should consider all of them. We have to be open to all innovative proposals to push back against authoritarianism. Today, I propose to put another suggestion on the table, another suggestion that could help defend democracy in the world. That suggestion is an international constitutional court. But who would the judges be? How would they be chosen? Who could file a lawsuit in this court? And what powers would the court have? That's the subject. That's the ground I wish to cover today in my lecture entitled, Does the World Need an International Constitutional Court? I might be pausing off and on over the course of my remarks because I have a little bit of a cough. And so please forgive me if I press mute for a second while I cough and then return. Thank you. The seeds for an international constitutional court, they were planted in a provocative essay published in a French newspaper about 20 years ago in 1999. The author of that essay was a doctor who was working in the area of human rights. And his name was Monsef Marzouki. In his essay, Marzouki rang the alarm on what he saw around the world. Attacks on democracy, attacks on the rule of law, often by authoritarian states that violate inalienable rights. Authoritarian states that hold rigged elections to give themselves a veneer of legitimacy. Authoritarian states that reform the Constitution to consolidate their power and to harm and exclude and minimize their opponents. Marzouki at the time was following in the tradition of a French political theorist, Georges Liet-Vaux. At the height of the Second World War, this French political theorist exposed the mounting evidence of political actors who were exploiting formal institutions to achieve non-democratic ends. For Georges Liet-Vaux, this amounted to what he called fraude à la Constitution. In other words, in translation, constitutional fraud. Half a century later, Marzouki, who was writing in 1999, he reminded us all that constitutional fraud was still evident all around the world. And so there was an urgent problem in his view, an urgent problem facing the international community. How to defend democracy from crafty political actors who can manipulate their own constitutional rules while at the same time proclaiming a commitment to constitutionalism, to democracy, and the rule of law. How can you do that? And in his essay, Marzouki sketched the broad strokes of his idea for an answer to that problem, his idea for a court to protect democracy. He proposed that the court should have one all-important objective in the near term and thereafter, which was to rule on the legality of elections around the world. And in the longer term, the role of this new court, which Marzouki called an international constitutional court, the role of the court would be to eradicate dictatorships and to guard democracy from defeat. And so when you read his essay, you see Marzouki wondering aloud about what body of law this new court would enforce, about who the judges would be, about how it would exercise its powers. One big question is, what jurisdictional authority would this international constitutional court exercise? Marzouki had an answer. For Marzouki, the court would be the guardian of three fundamental texts in global governance. First, the Universal Declaration of Human Rights. Second, the International Covenant on Civil and Political Rights. And third, the International Covenant on Economic, Social, and Cultural Rights. The International Constitutional Court would defend the values, the rules, the principles in these three important texts. Values and rules and principles that Marzouki believed all states should honor. That was then in 1999. Since Marzuki published his pivotal essay, two major trends have emerged. First, Marzuki has been proven right. The problem of constitutional fraud has only worsened since 1999. In fact, democracy has declined every year since 2006. And this trend today shows no sign of reversal. On the contrary, the global decline in democracy has only grown steeper and faster. Today, only 6.4% of the world lives in a full democracy. Dictatorships are far more populous than democracies. Today, dictatorships govern 70% of the world. And so this split that we're living today between democracy and dictatorship has pulled us back to the lowest levels of democratic governance since 1989, before the fall of the Berlin Wall. That's the first trend. The second trend since 1999 is really a direct response to the first. The distressing decline of democracy has had the positive consequence of focusing the energies of scholars and political actors on diagnosing the problem of constitutional fraud and on brainstorming ways to rescue democracy. And so today, scholars are taking constitutional fraud more seriously than ever before. Scholars have created new theories, new concepts that are direct descendants of Liet Vaux's theory of constitutional fraud. One of these theories is a theory advanced by my colleague David Landau, who's written about the phenomenon of abusive constitutionalism. David has shown just how easy it is for authoritarians to use the mechanisms of constitutional change in order to make a state significantly less democratic than it was before. These kinds of changes that David discusses, they sometimes slice so deeply into the heart of the Constitution that they really eviscerate the Constitution while keeping legal continuity with the Constitution. It's a very interesting paradox. I myself have theorized that we should understand these changes not as mere constitutional amendments, but rather as constitutional dismemberments, because they do violence to one or more of a constitution's essential features. For example, its fundamental rights, its basic structure, or a core feature of its identity. So all of this raises a puzzle, which my colleague Kim Lane Shepley has defined as autocratic legalism. Autocratic legalism. The challenge is, how can we spot and stop autocratic legalism before it's too late? Today, we have some academic resources at our disposal to help identify threats to constitutionalism, to defeat authoritarianism, to build safeguards for democracy. And I was heartened to see that the Biden administration has launched a new initiative, a new summit for democracy, along with associated initiatives. These are sending strong signals to autocrats around the world that democratic leaders are joining forces to take deliberate steps toward global democratic renewal. Among the many strategies to fight back against the tide of authoritarianism that we see around the world, we have yet to see a real fulsome discussion of an idea for an international constitutional court. This idea has yet to catch fire among defenders of democracy. Virtually no one is talking about it, but the question from my perspective is why? Is it really such a bad idea? Marzuki, the person who wrote the essay in 1999, he never relented on his idea to create an international constitutional court. Even before he published that essay in 1999, he'd long been a believer. He was a devoted Democrat, a committed constitutionalist, and a champion of human rights. But you'll recall, he was a doctor, and there was little he could do to put into motion the creation of the court as a doctor, as an essayist, as a physician with no role in government. That was 1999. But things changed 12 years later in 2011. That's when Marzouki became the president of Tunisia. And soon after he was sworn into office, he convened and chaired a group to think about precisely the subject about which he wrote this essay in 1999, about creating an international constitutional court. And the group that he created and chaired was called the Ad Hoc Committee for the Establishment of an International Constitutional Court. His committee developed a detailed proposal for this new global constitutional tribunal. It's a very interesting proposal. I want to tell you a bit about the technical aspects of the committee's vision for an international constitutional court, including its composition, its function, its jurisdiction, and its authority. I want to warn you that some of you may find yourselves underwhelmed by the details of the proposal. Some of you will see great promise in the broad strokes of the proposal that I'll lay out for you. But I suspect that most of you will fall somewhere in between being underwhelmed and being really invigorated about the idea. You'll fall somewhere in between, which is where I find myself right now. So, the proposal. The court is to have 21 judges elected by the General Assembly of the United Nations. The Assembly would select these 21 judges from a list of roughly 200 nominees, one each from the member states in the UN. And that list of 200 would be pared down to 42 before the Assembly would make its selection of the 21 judges. And the court, once created, would have two principal functions: giving advice, resolving disputes. In its advice-giving function, the court would issue advisory opinions at the request of governments, of political parties, of professional groups, NGOs, multinational organizations. And the court would be authorized to give advice on texts or draft texts related to democracy and rights. Draft texts of amendments, for example, draft texts of constitutions, for example. And the advice the court would give would be whether the draft text is consistent with democracy, with rights. And the court would have 6 months to issue its advisory opinion. That's the vision the committee has for the advisory function of the court. In the court's second function, its dispute resolution function, the court is to rule on what the report defines as serious violations of democratic principles and democratic conditions for elections. And the court can hear complaints from political parties, professional groups, NGOs, multinational organizations. Anyone who wants the court to hear their claim, however, must first exhaust all options available domestically within their jurisdiction first, before going to the International Constitutional Court, according to the committee's report. And when a complaint is brought to the court can then try to mediate the dispute. Otherwise, the court is to issue a judgment on whether the claims reveal a violation of democracy or of rights. And finally, the court's judgment is intended to be binding on the state or states implicated in the dispute, meaning that the state must implement the ruling of the court. In exercising both of these functions, the advice-giving function, the dispute resolution function, the court is to be guided by what the report describes as the principles and rules relating to democracy and civil liberties. But that, for me, raises a question. What exactly does democracy demand? And which civil liberties will the court be tasked with protecting? The jurisdiction of the court, according to the report, is to extend broadly around the world to require the court to enforce the rules that appear in a series of texts, not just the UN Declaration of Human Rights, not just the International Covenant on Civil and Political Rights, but also the Treaty on European Union, the European Convention on Human Rights, the Charter of the Organization of American States, the American Convention on Human Rights, the Inter-American Democratic Charter, the Constitutive Act of the African Union, as well as the Harari Principles. So, as you can see, this is a vast portfolio for any court. Those are the details that the report sets out about the construction, the jurisdiction of the court. But what about the larger vision that the committee has for the court? Because it does have a larger vision for the court. The committee states directly and without qualification that its goal in creating this international constitutional court is to internationalize constitutional law. In other words, to create and to enforce a constitution for the entire world, a world constitution. I want to read directly from the report so that you hear for yourselves what the committee actually believed about the role of the court and what it should be in relation to the world. I'm going to read directly from the committee report. Emphasis should be laid upon the internationalization of constitutional law. In other words, upon the principles of domestic common laws common to nearly all nations. They are norms relative to the fundamental rights and freedoms of citizens, to the democratic basics of political power, and to the organization of the political and judicial jurisdictional power. An international constitutionality definitely exists, end of quote. That's from the report. And so for the committee, the role of the court is to determine what qualifies as international constitutional law, to separate what falls within the scope of a constitution for the world from what extends beyond a global constitution, and then to enforce that world constitution in claims brought to the court. It's a very large, impressive, challenging vision for the court. Now, I think there are some major challenges to the viability of an international constitutional court, because you can create it. Hard to do that, but imagine you create it, it will still confront some really serious difficulties. And one of those challenges is the problem of authority. The problem of authority. The UN would be the body responsible for overseeing the International Constitutional Court, according to the committee. The court would be created by the UN, and its members would be chosen by the UN General Assembly. And the court would apply texts of higher law in the UN. Now, when the UN was created, of course, there were sky-high aspirations for it, but I think we can all agree that the aspirations for the UN have so far exceeded its achievements. And I think it's safe to say, fair to say, that there are around the world increasing signs of disenchantment with the United Nations, because the failures of the UN are very well known, and each is a very real catastrophe. I can list some of them for you: Rwanda, the oil for food program in Iraq, civil wars in South Sudan, Syria, Yemen, the Rohingya crisis, Kashmir, Haiti. It's really a long list. Perhaps the most recent prominent failure of the UN is Russia's attack on Ukraine, an attack that the UN is powerless to stop, because Russia is one of 5 permanent members of the Security Council, and therefore it has a veto over anything the UN does. And so all of this paints a portrait of great tragedy, and all of it undermines the authority of the UN as a body that can help manage global governance. This is the view that many have. My own view about the UN is different. I continue to believe that the UN holds hope for bringing peace and stability and prosperity to all parts of the world, but I am probably in a minority, I have to admit. And so that's why I think the idea of an international constitutional court housed within the UN, that's why it confronts a problem of authority. A second challenge, perhaps an even bigger one, may be the problem of enforcement. When the International Constitutional Court, will the wrongdoer actually listen to what the court says? So imagine a democracy promoting party files a claim in this International Constitutional Court. Imagine that party argues that a recent election in an autocratic state was undemocratic. Imagine that the court hears the claim, and imagine the court concludes that the authoritarian government did in fact engage in clear and flagrant violations of standards of electoral fairness. Then what happens? The answer is probably nothing, because the election result is unlikely to be reversed, nor will a new election be called. The country is likely going to continue to operate as it is, which is to say, under the rule of an authoritarian leader who rigs elections. I mean, there are some examples around the world of authoritarian states who actually do comply with supranational court rulings, if only in a limited way, but those are the exception and not the norm. And so I worry about the problem of enforcement. The International Constitutional Court may issue a ruling, but will states comply? I want to make a distinction, though, on the point of enforcement between a global supranational court and a regional supranational court. Because if what you care most about is compliance and enforcement, perhaps a regional supranational court could work better than a global supranational court. If that's the case, this would suggest that perhaps we should be thinking less about the possibility of an international constitutional court and more about creating regional constitutional courts. The interdependence and commonalities among countries within the same region might make it more likely that a regional court of their peers could persuade a given country to comply with a ruling issued by a court that's rooted in the region. These countries might respond better to a homegrown local tribunal constituted of local persons, regional persons, rather than to a foreign body that's located somewhere out there and staffed by persons not from here. And so perhaps a regional constitutional court could balance the need for a distanced, arm's length evaluation of a claim of wrongdoing within a given country, while not relying on a court far, far away, unfamiliar with the local realities of the country and its people. And so perhaps this idea of a regional constitutional court might alleviate the problem of enforcement. Maybe. On the other hand, a system of regional constitutional courts would fail to fulfill the single most important objective from the proposal of this committee for an international constitutional court, which of course is to build and enforce one world constitution. So, any questions here that are raised by the creation of an international constitutional court? There may be a practical reason why a system of regional constitutional courts might work better than one single international constitutional court. And that reason is quite simply that we already have tribunals around the world that operate as regional constitutional courts. That infrastructure has already been built. And so this raises the question, which is, why not just improve upon that existing infrastructure? I'm thinking here of the African Court on Human and People's Rights, the European Court on Human Rights, the Inter-American Court of Human Rights, for example. These are regional tribunals, and their purposes are much the same as the ones envisioned for the International Constitutional Court. Things are not, however, that easy, just to say, well, let's just use these existing regional constitutional courts. Because the existence of regional courts that currently operate around the world, I think, opens the door to a different problem. It's not a problem of authority. It's not a problem of enforcement. It's a problem of coordination. How to coordinate the work of courts when their jurisdiction overlaps. I think this challenge might be especially pronounced for the member states of the European Union. They have their own domestic courts, and they are subject to the jurisdiction of their own supranational courts. And now they'd also have the overhang of an international constitutional court. The problem of coordination, I think, would be considerably easier to overcome in countries where there is no supranational regional court operating at the moment. And so these are three major problems standing in the way of an international constitutional court. The problem of authority, which is really a problem of legitimacy, the problem of enforcement, and the problem of coordination. There's also another problem, which is the problem of political will, which does not exist today to create such a court. The question that these problems raise for me is this: are all of these problems, are they enough to dissuade us from the idea of an international constitutional court? In other words, should we give up on this idea altogether? Remember that the ad hoc committee suggested two functions for the court. One was to resolve disputes. That's principally what we've been discussing so far. Can an international constitutional court resolve disputes in a way that will be treated as binding, that will be seen as legitimate, that will be received as valid? I'm not convinced that this is a plausible path for the court, due largely to the three problems that I've identified, the problems of authority, enforcement, coordination. But remember that the ad hoc committee's report also suggested a second function for the court. And I think that function could be the right path forward for the court, if indeed the court is ever created. And that function is to give advice. The court could hear claims of wrongdoing in rights protection or elections as it relates more broadly to democracy, but rather than issuing an order that is unlikely to be followed, the court could instead issue an advisory ruling in which the court outlines its own understanding of the facts, along with what the court believes democracy requires according to the expectations set out in the fundamental texts in global governance. The jurisdiction of the court would not change. It would be limited only to issuing advisory rulings. That's it. That's it. You just give advice. Now, I'm trying to anticipate what you might think about this point, that we might take away the court's power to resolve disputes and rather limit it to just an advisory function. I'm trying to anticipate what you might think about that. I suspect that you might think, well, this would make the court toothless and ineffectual. Maybe, that's possible. But it's not necessarily the case that that's what would happen if the court were to give advisory opinions instead of resolving disputes. Because I think sometimes advisory opinions can have a catalytic effect in constitutional politics. They can send a strong signal of wrongdoing around which the opposition can mobilize support, about which the media can write, and about which laypersons can read for themselves to see how the conduct of incumbents in their country measures up to standards for democracy. It's true, of course, that advisory opinions do not always have that catalytic effect, because sometimes advisory opinions fail. That's why I want to suggest that if indeed this is the role for the International Constitutional Court, that we will limit it to giving advisory rulings. I want to stress that the best advisory rulings will have to share three properties: unanimity, specificity, practicality. If you want the court to be effective when it issues its advisory opinions, those are the three properties that its rulings must have: unanimity, specificity, practicality. First, as with any ordinary judgment, it's always better if the advisory ruling is unanimous. Unanimous judgment in this international constitutional court would resonate more powerfully in the jurisdiction where the claim has arisen. Because imagine if the 21 judge court splits 11 to 10 on a question about whether a certain set of facts or actions runs afoul of democratic standards. That would be considerably less impactful than if all of the court's 21 judges speak in one voice. So unanimity is a key factor here. It also matters how well the court's judgment reflects the history, practices, and political dynamics of the local jurisdiction. The more familiar, the better, and the more likely the ruling is to be seen as relevant in that jurisdiction. And so the second point is really about specificity. The local specificities matter, and the court's advisory opinion, in order for it to be effective, should reflect its awareness of those local specificities. And finally, third, it's important for the advisory ruling to be attentive to the legal, political, and social realities that make it difficult sometimes to fix problems in the infrastructure of democracy. Now, it's ordinarily difficult to make reforms, both in law and in politics. And so presumably, if the International Constitutional Court issues an advisory ruling that finds a violation of a democratic standard, the court will state that finding and explain how and where the wrongdoer has fallen short. This would be an essential part of any advisory ruling the court would issue. But the court should also do something else. It should offer a roadmap for reform. In other words, how can the wrongdoer go from failing to meet the democratic standard to satisfying that democratic standard? So that's why I think an advisory ruling would be most effective if it answers that question too. This third factor is about practicality. How do you get from violating democracy to defending democracy? That should be in the advisory ruling of the International Constitutional Court. So 3 factors that I think could strengthen the advisory role of the court: unanimity, specificity, and practicality. I'm going to close now, and I look forward to any comments you have. The International Constitutional Court as an idea, I think it's a very provocative idea. And it comes at a time when democracy, as we've discussed, is under attack around the world. I think it could be a useful shield in the fight to protect democracy. But if this idea is to work, I think the proposal has to be refined. The proposal from the committee has to be refined in order to improve what the committee suggested in its report. Not only to limit the court's role to simply giving advisory opinions, but also to introduce a number of principles, guiding principles, that should really serve as parameters around which the International Constitutional Court should do its work. So let me offer, as by way of closing, 5 guiding principles for building this International Constitutional Court. 5. The court should be international, inclusive, representative, independent, advisory. Let me say a word about each and then we'll close. First, the court has to be housed in an international organization whose member states include all the countries of the world. If this means the UN, then it must be in the UN. As I mentioned, I'm optimistic, I'm hopeful about the role the UN can have in the world. Second, this means including democracies, autocracies, and others in between in the project to create an international constitutional court. Because even if autocracies are unlikely to abide by the court's rulings, they have to be included within the court's jurisdiction. So that's the second point, inclusivity. Third, the judges of the court have to represent the rich diversity of all the peoples of the world, from the different regions of the world, to the legal traditions of the world, to the different systems of government, and beyond. That's the representative function of the court. And then fourth, the court has to be seen as independent, and it must be independent. And so the selection of judges, I think, is what matters here the most. How they're selected, how long their terms last, and how and whether they may be removed before the end of their term. And finally, fifth, as I've discussed, the function of the court should be to give non-binding advice through advisory rulings, not to issue binding rules that I believe are likely to be both unenforceable and, in some cases, disregarded. So those are the 5 principles that I believe should guide the creation of an international constitutional court. I think the idea as developed by the committee, the ad hoc committee created by President Marzuki, I think the idea has to be refined much more granularly than how it is presently defined in the report that was issued about 10 years ago. And I think the effort is actually worth, I think the effort could yield some progress. It may not yield the creation of an international constitutional court in the end, perhaps not, but I think it's worth the investment of our time because we have to brainstorm innovative ways to defend democracy. And I think it's also a good idea because it's a way to bring allies of democracy together in a productive way, a way for the defenders and advocates and proponents of democracy around the world to build something together. And perhaps in the process, we'll conclude that it's an idea that's not worth pursuing, and that'll be fine. Maybe in the process, we'll find an even better idea. That would be a victory for democracy, for your country, for my country, and for the world. But I don't think that the idea of an international constitutional court should be rejected without thinking about it very carefully, about how and whether it could work. I've tried to do that today in my discussion with you. We can do that together in a moment in our time for comments and discussion. And I'm going to continue to think about the idea of building an international constitutional court, and I hope you will too. Thanks so much. I look forward to our time for discussion.
Thank you, Richard, for your excellent lecture. We have quite a few questions. The first question that I would like to put to you is from Deb Zukman. I think that's a Scandinavian name. I'm not entirely sure that I have pronounced the name correctly, and I apologize if I haven't done so. He has a question for you and also a comment. He asks, is the United Nations Security Council permanent 5 members not an avenue to pursue a real-world binding constitutional court that all nations can use as an avenue to pursue such a binding court? And he also comments that he is in the minority. He thinks that UN has done a remarkable job. I think he has mentioned it as one of the most remarkable creation of human mind. So, Richard, your answer and thought on that question and comment. Thank you.
Yeah, thank you, and good to have you here, Dave. Very nice of you to make the time to join us, and thanks for your comments. I wonder whether this is something that could be created just by the Security Council. I'm not sure that that's possible, both technically, but also in terms of the legitimacy of the decision-making output. I think this is the kind of thing that should involve all member states. Even if it's true that the Security Council could create it on its own, I think it would maybe undermine the legitimacy of the court if it's created without the participation of the others. Now, I think it's certainly true that someone on the Security Council, one country, permanent member, could certainly veto it. That's absolutely true. But I would worry that if they chose to create it on their own, as remarkable as that would be, for the 5 permanent members to say, yes, we agree, and then we're going to create it, I would encourage them instead to seek the input and also the validation of the entire membership of the General Assembly. But it's an interesting question, very interesting question. Thank you so much, Dave.
Thank you, Richard. The next 2 questions are from my colleague, Mr. Nafiz Ahmed. Nafiz asks, can it be Can it not be said that the role suggested for the proposed international constitutional court be played by the international civil society or academia? And he also asks, if internationalization of constitutionalism is successful, will it not lead towards moral colonization by the West?
This is another important challenge to the creation of any institution, any global institution. The fear that it will be dominated by, let's call them, as your colleague did, Western powers. That's a concern. As to the staffing of the court by academics, I think that's a possibility, because remember, under the proposal as advanced by this committee, it would be the individual member states that would get to make nominations for who would sit on the court. And I would suspect that some nominees would be academics, maybe not all of them, but at least some of them would be academics. Some would be sitting judges. Some might be former presidents, former prime ministers. And I think that would be the way to go, to have a mix of persons who bring different kinds of experiences, different kind of expertise to the task of judging in this advisory way that I'm suggesting would be the best way for the court to do its work. But you're quite right that an additional challenge, in addition to the problem of enforcement, of authority, of coordination, would be this problem of perception. And I think it goes to the problem of authority, really. The perception, the fear that this global institution would really be dominated by, let's call them, as you said, Western powers. I think the way to counteract that would be to have a very robust, open nomination process, robust, open, and fair election process for the 21 judges who would sit on this court. And by the way, let me just share with you all, I don't know if I can put something in the chat box, but I have written a draft paper with these ideas, and if you're interested in reading it, here's the link to where you can download it.
Thank you, Richard. Maybe I should have shared that link. I forgot. So thank you for inserting that link. Nafiz also has another question to you. He asks also, will internationalization of constitutional law not be the death of constitutional law?
Well, this is, I think, a fascinating question about sovereignty, which is to say, when you give up the right to have the final word about the form, the function, the content of your own domestic constitutional law, are you not also in some way giving up some measure of your sovereignty? Constitutions, of course, are not just domestically defined and drafted and promulgated documents. Many constitutions around the world are actually the result of international coordination, international efforts. And so I want to, I guess, take exception to the premise of the question, which is that a constitution is necessarily a jurisdictionally bound set of rules. More and more over the past generation, even since before, of course, but more and more over the past generation, the process of constitution making has been an international effort. And so if you think back to the writing of new constitutions in Japan, in Germany, in the post-World War, that was maybe the beginning of the modern vanguard of international constitutional creation. Of course, that context was different. Those were imposed constitutions, let's call them that. Now, sovereign states are requesting international participation in their domestic constitution making activities. And so I think that actually makes it safer safer in regard to the question that your colleague asked, safer in the sense that we don't have to worry as much about attacks on sovereignty from global institutions that would have the power to interpret domestic constitutional rules. It's safer in the sense that now many constitutions are the product of these international efforts. And so the boundary that separates what is truly and exclusively domestic from what is more global, more regional, more international, it's much more blurry now than ever before. And so I think that opens the door to the possibility, I think, of creating a court that would have the powers that we've discussed.
Thank you, Richard. The next questions I should say, we have is from Nawaf Al-Qahtani. I hope I have pronounced that correctly. The questions are, can the International Court of Justice be granted jurisdiction over these issues without the need to establish the International Constitutional Court? And secondly, is it possible to get benefits from the experience of the International Criminal Court?
Absolutely. So we have so many international courts around the world from which we can learn. They're building a deep reservoir of experience that can help us maybe learn about how to deal with the problems that I've mentioned, how to deal with the problem of authority, which is also a problem of legitimacy, how to deal with the problem of enforcement, the problem of coordination. So there are many courts out there that we can learn from. In fact, there's an institute, it's called I-Courts, short for International Courts, that studies this very question. And so that would be a great resource to draw from in building this international constitutional court. In fact, if someone is interested in pursuing this idea of an international constitutional court, I would recommend being in touch with the people at I-Courts so that you could learn from what they've learned about what makes international courts effective and what kind of things international courts need to do to overcome these problems that I've outlined, the problem of enforcement, of coordination, and of authority. So yes, absolutely, there will be challenges. Absolutely, it will be very difficult to create this, but there are great opportunities for learning about how other international courts around the world, certainly different from the one I'm proposing, but other international courts around the world have dealt with similar kinds of challenges.
Thank you, Richard. The next question that we have is from Tarazi Muhammad Sheikh. She asks, how do you describe the balance between the sovereignty of a state and the jurisdiction of the International Constitutional Court, given that sovereignty of a state is one of the fundamental elements of a state?
Mm-hmm. Well, we've touched on this question just a moment ago in relation to sovereignty, but I suppose we can ask the question another way. May a state waive in part the power to interpret its own constitution as a final matter without waiving its sovereignty, without compromising its sovereignty? Stated another way, can a state agree to place itself under the umbrella of this international constitutional court while still calling itself and being seen as a sovereign state? I think the answer is yes. I think the answer is yes. I suspect that when a country is deciding whether or not to accede to the jurisdiction of this international constitutional court whenever it's created, I suspect that many countries would do it by executive decision or by parliamentary ratification or by referendum or some combination of these decision-making devices. And so as long as the decision-making device, the vehicle that the country uses to accede to the jurisdiction of the International Constitutional Court, as long as that device, that vehicle is seen by those in the home jurisdiction as legitimate, then I think it's okay. Then I think we can balance the nature of modern sovereignty of states with the reality that the final word, in an advisory way, the final word about the nature, limits, restrictions within the state's apparatus of governance would be coming from a third-party international institution. I think we could find that balance, because the choice, after all, the choice to accede to the jurisdiction would have been made by the domestic actors. And so I think if the choice is made that way, that's how we can balance what you, I think, very helpfully describe as the tension between the long-standing and central idea of sovereignty and this international constitutional court, this international body that would seem, I think, to compromise, to challenge the traditional notion of sovereignty. But I think there's a way to reconcile those two. And I've proposed, I think, my initial thought about how that might be done.
Thank you, Richard. We have a question from Professor Rizwanul Islam. He asks, every international court is enforcing a constituent document, say international law or convention. Where is the international constitution here? If the Bill of Rights, then it is going to be a court of human rights. On the other hand, do we have an enforceable right to democracy? Thank you, Richard.
Thank you for that question, and good to have you here, Rizwan. Or Ridwan, rather, because Rizwan is the host. Ridwan is a co-author of mine, actually. We're working on a paper right now, a very interesting paper, which is on whether a constitution can be unconstitutional. We know that constitutional amendments can be unconstitutional, but can a constitution be ruled unconstitutional? And so this is a paper that Ridwan and I are working on. I look forward to continuing that and to share it with all of you. On the question, this is something that the committee convened by President Marzuki, something that they talked about. In their aspiration to create an international constitution, a world constitution, they confronted the question, well, what documents would this international constitutional court be enforcing when it exercises its power to resolve disputes or to give advice? And the committee came up with three major documents that, in its view, when you put them together, actually do amount to something close to an international, a world constitution, beginning with the UN Declaration of Human Rights. And so, while they're not created and defined and recognized as constituting a global constitution, a world constitution, the committee wants us to group these three documents together: the ICCPR, the Covenant on Economic, Social, Cultural Rights, the UN Declaration of Human Rights, wants us to group these together and to see them, begin to see them as the constitutive elements for a global, world, international constitution. That's what the committee would be defending. Those are the set of rights and responsibilities and duties and protections that the International Constitutional Court would be referring to when evaluating conduct by state actors who are alleged to have violated the fundamental commitments to democracy and to rights. Now, whether it ultimately works and people eventually see these documents as constituting a global constitution, I don't know. There'll certainly be a challenge to that. But that's the vision of the committee. I might have different kind of documents that I think would constitute better a world constitution. You might think, we might think together that it might be a useful exercise for the global community of political actors to come together to write a world constitution. That'd be very interesting to do. Imagine a global constituent assembly where the product of that assembly would be sent to the countries of the world for their ratification, for their choosing whether or not to adopt it and to give it the stamp of approval as their world constitution. Very fascinating. I think the project of creating an international constitutional court opens up many avenues for future research and also future action. And one further avenue of research is how to actually build a global, a world, an international constitution. That's very exciting. I think very, very interesting. Thanks so much for that question.
Thank you, Richard. We are almost out of time, so I'll just put two more questions to you, and these would be our last questions. One is from MD Aftabur Rahman. His question is, as we believe democracy means the choice of majority, but do all the people of the world desire for the same choice? If so, countries would not have wanted independence. Then isn't the idea of international constitution itself, constitutional court itself, a threat to democracy? And the question that I would like to put to you is, as you are pointing out, both in your paper and also in the lecture, that maybe authoritarianism is on the rise. So if so, where would the impetus to such a court, do you think, eventually come from? Any thought on that, Richard? Thank you.
Yeah, it's a difficult question, your question, Rizwan, because if the ambition is to gather all of the countries of the world together in agreement behind building this international constitutional court, what incentive do authoritarian states have to say, yes, we're going to join? I think it's very interesting that when you look around the world and you look at the countries that have constitutions, it's very simple answer to the question, who has a constitution? Everyone has a constitution. And there's a reason why everyone has a constitution. Is that it's the price of admission into the international community of states. Even North Korea has a constitution. If you read the North Korean constitution, it actually is much more effusive in the rights that it protects than the US Constitution. It's very interesting, isn't it? You compare the two constitutions, the texts, side by side, without knowing which constitution belongs to which country. You might say, I want to live in this country that has this constitution, without knowing that it's the Constitution of North Korea. The point here, Rizwan, is that the incentive for authoritarian states to accede to the jurisdiction of the International Constitutional Court would be the same. It would be that this is something that the international community expects of jurisdictions, whether you're a democracy, whether you're autocracy, whether you're somewhere in between. And because, as I'm proposing the International Constitutional Court to exercise its power, because I'm proposing that it be advisory opinions only, that I think would make it much more politically palatable for authoritarian states to say, yeah, fine, we'll join. Everyone else is doing it. We'll do it too. We don't want to be the only ones not in that group of international actors. Because the fact that the rulings are advisory and not binding would allow the authoritarian states to, one, shirk their responsibilities, which is a bad thing, shirk their responsibilities by not acceding to the demands, to the not following the advice of the advisory International Constitutional Court. So they could shirk on their responsibilities. But I suspect that over time, as the International Court issues repeated judgments, advisory judgments, that point the finger at these authoritarian states for the things that they're doing, that would give the opposition in these authoritarian states things that they could point to for the people, so the people could see just much more clearly what the incumbents in this authoritarian states are doing. And that would, I think, perhaps, as I suggested in my remarks, perhaps have a catalytic effect toward making change, toward changing the regime, toward improving the regime, improving democracy in even authoritarian states. This is a hopeful, optimistic view, yes. But I think that because we're now confronting a world where democracy is on the decline, authoritarianism is rising, we really have to try every single option before us. And this idea of an international constitutional court, it's not a perfect idea, far from it, far from it. But I think it's an idea that holds some promise for making some progress in defending the values of democracy. That's why I'm suggesting that we start small with an advisory opinion, with rather an advisory function for the International Court, rather than starting right away and saying, well, we'll give it the enforcement power, only then to see that countries just don't agree to conform their conduct to the rulings of the court. We don't want to give the court this inauspicious start where it's created and it's given this power to resolve disputes, but then no one ever listens to the court. That's why I suggest advisory rulings would be best. But for me, this discussion has been evidence of two things. One, that there are really interesting people in the group with interesting ideas from which I have a lot to learn. So thank you for that. And two, that this is an idea that I think is very interesting for sparking conversation, and that I think if all of us as Democrats, those who love democracy, want to defend democracy, if all of us as Democrats continue to think about and talk about that, maybe we can arrive at a point where we refine the idea of an international constitutional court to the point where it could actually work. And so I want to thank all of you for your comments and your questions. They've been interesting and challenging, and I'm certainly going to use them as I continue to think and talk about this idea. Thanks so much.
Thank you, Richard, once again for your time and for the wonderful lecture. Thank you to the audience for their participation and the questions. Have a good day.
I just also want to thank Rizwan. One last thing. I want to thank your team. You have a number of TAs here with you, a number of colleagues, and I just want to make sure that I recognize them for all they did to help put this program together. So thanks to each of you. And thanks again, Rizwan, and to North South University. It's been a great pleasure.
Thank you, Richard.
All right.